Hey everyone, this is MWhitehead, and this is my assignment, Criminal Responsibility and Defenses. Our assignment was to research a case that has occurred in the past 40 years in which a defendant was acquitted on the basis of either legal insanity or intoxication. After doing some research, I found State v. Phillips, which was finalized in 1996, but the crime occurred in 1990. The defendant entered a branch of the First Tennessee Bank and forced tellers at gunpoint to hand over money, and also forced the branch manager to accompany him to his getaway car. She was able to escape when the dye packs exploded in the money bags, and he was captured shortly after. The defendant was charged with aggravated robbery, 3 counts of aggravated kidnapping, and 2 counts of especially aggravated kidnapping, but he was found not guilty by reason of insanity. He was sentenced to 60 days of mental health evaluation, for which he appealed against, saying it was against his rights to due process. I personally do not agree with the verdict. I feel that just because the defendant was suffering from depression with or without psychotic features, it should not legally excuse him from all legal consequences of his actions. In the doctor's testimony, he even stated that the defendant knew what he was doing was wrong at the time of the crime, but he was unable to control his actions. And I do not feel like just because he had impulse control issues and could not control his actions, that it should excuse him from all legal consequences. He may not have to have the exact same charges and sentencing as someone who is not suffering from impulse control issues, but I do feel that in this case he should have had to serve some time. One of the arguments I have against the determination of legal insanity is one that the book discusses, which is irresistible impulse test. I find this to be flawed because I don't feel that someone should be able to say that they can't control themselves when committing an act, therefore they shouldn't be held responsible for the act that they did. It seems like it would be an open door for even harsher crimes other than just robbing a bank or petty theft or whatever. And I feel that just because someone says that they can't control their actions, just because they have impulse control issues, doesn't excuse them from the behavior that they have. I think that if they know they have impulse control issues, they need to be seeking help for those impulse control issues, or they should be locked up where they can't commit the unlawful acts that apparently they can't control themselves from doing. I'm not sure if this case specifically used the irresistible impulse test that the book describes, but they did state that the defendant knew what he was doing was wrong but had no control of his actions, so it sort of relates to it. Also, I feel that acquitting someone of all charges without giving them harsher repercussions other than a 60 to 90-day stay in a mental facility to determine whether or not the defendant is no longer a threat to themselves or others on the basis that they are not currently insane or intoxicated, but they were legally insane at the time of the crime, is a free pass to bad behavior and too difficult to determine if they were actually insane at the time of the crime or not. Extreme circumstances could be considered, such as abuse victims finally sticking up for themselves and physically assaulting their abuser or something to that effect. Also, in Tennessee's previous law for crimes committed before July 1st, 1995, stated that the burden was left up to the state to prove beyond a reasonable doubt for the defendant was sane at the time of the crime. The law has since changed, but I think that since the crime was committed before this date, so it was a factor in determining the outcome of this case, it was a negative factor because I'm not sure how I feel fully about the state having to be the one to prove sanity of a defendant. It seems that it would be an easy way out of making bad choices and doing unlawful acts, because how easy is it to prove someone's sanity, really? My arguments for the determination of legal insanity in this case would be when the court used the mental health doctor evaluation of the defendant to determine if the defendant is currently mentally insane. I don't fully agree with having a doctor state that based on what the defendant says they felt at the time of the crime, the doctor should be able to legally state that they were insane at the time of the crime. But I do feel that having a mental health doctor be able to determine whether or not the defendant is currently legally insane or not is good to use when determining if a defendant is still a threat to themselves or others. Another factor for the determination of legal insanity I think is good is the previous law stating that the burden of proof is on the state to prove that the defendant was sane at the time of his or her crime could be considered a good thing only because in criminal cases it's usually the state's burden to prove beyond reasonable doubt that the defendant is guilty of a crime, so that it would be reasonable to say that the state should also have the burden to prove beyond a reasonable doubt that the defendant was sane at the time of a crime that they are saying they were insane for. However, that law has since changed, giving the defendant the burden to prove insanity with clear and convincing evidence, which I, again, feel is a good thing because, in all honesty, how does someone determine the sanity of another person from past events? I know that legally speaking, it should be up to the state to determine the guilt of the defendant, so therefore the state should have to prove that the defendant was sane at the time of the crime. But I also think that without having the defendant hold at least some burden of that proof, too many people could use insanity as a defense when in fact they were not insane at the time of the crime. And because it would be extremely difficult to prove that they were sane or not sane at the time of the crime, that people could claim insanity and get away with doing unlawful acts when in fact they were perfectly sane, but it's something would be hard to prove against if the burden was still on the state. My analysis of the state statute 39-11-501, I feel that the state statute lays out exactly what should be determined and what does not determine legally insane very well. It states that repeat criminal behavior does not count as a mental disorder and that mental disease or defect caused the defendant to be unable to appreciate the nature or wrongfulness of their acts. I agree with this because I don't feel that just not being able to control oneself should constitute as a pass for unlawful acts. I think there should be other factors such as not being able to appreciate the nature or wrongfulness of their acts while not being able to control their actions. My analysis of the federal statute, Title 18, Section 17, the only part missing from the federal statute from the Tennessee state statute is that in the state statute, the defendant cannot use expert testimony to prove they were insane at the time of the crime. I think that part is important because it is not difficult to find someone and pay them to say that they believe that they were insane at the time of the crime. I think that unless a doctor is a witness to the crime and could tell them what they saw at the time of the crime and say that yes, this is a clear sign that this person was insane at the time of this crime, they should not be able to be an expert witness stating that they believe the person was insane at the time of the crime. So I think that's very important for the statute of legal insanity. So that is one thing I would prefer to see in the federal statute that Tennessee does have. Factors that I would want the court to consider if a defendant pleads insanity or intoxication in order to find them guilty or not guilty would be whether or not the defendant was able to understand the wrongfulness of their actions, whether or not the defendant could control their actions because they were or were not aware of the repercussions of their actions, whether or not the defendant was acting out of a history of physical or mental abuse towards their abuser, because this one I feel is very important, because a person who has been physically abused and mentally abused for a long period of time may know that hurting someone is wrong, but because they feel that it's either them do something that is unlawful, or that person that they do this act to might end up hurting them, they feel that there's no other way. Now for intoxication, this one's a little iffy for me, because I feel it can only be a defense if there was no history of intoxication, such as someone who is young and never drank before and would not be able to tell you what being intoxicated would do to them. Also, if the defendant was intoxicated by force or persuasion by means of threat, meaning someone had put something in their drink, causing them to be intoxicated, or forced them to be intoxicated because if they didn't, that they would do something to them or their family. Not merely peer pressure, where someone feels the need to drink because other people are of their age, their peers, are drinking, but actually feel threatened by the person forcing them to be intoxicated or drink, which would then cause them to become intoxicated. I think that any unlawful acts that happen in the course of that, if the intoxication was because of force or there's no history of intoxication, that would be a factor for determining legal intoxication. Therefore, they shouldn't be held at least fully responsible for their actions, but maybe some responsibility depending on what the crime or unlawful act was. However, when talking about merely intoxication of an adult who has drank regularly over a period of time, they know what's going to happen, they know what could happen, but they still choose to drink and still choose to drink and drive, or they know that if they drink a certain liquor that it makes them angry, but they enjoy the fun they have while doing it, so they do it anyways, end up hurting someone or stealing or whatever it is they do. I don't feel that just because they're intoxicated at the time of whatever crime they do, it should be a pass for whatever crime they did, because before they were intoxicated, they knew what could happen if they became intoxicated, and then chose to become intoxicated anyways. And I think that waives any defense of, oh, well, I was intoxicated, I shouldn't be held responsible for my actions, I couldn't control them, when they could control whether or not being intoxicated or not. And this is the end of my presentation. I know that while doing my presentation, my arguments against and for the jury's determination whether the defendant was legally insane or intoxicated sort of overlapped in this particular case, but I feel that's because I think what could be good in this case might not be good in every case, and that's how determining legal insanity and intoxication would be. It's something that is going to vary from case to case, and even though two cases may seem exactly the same, they might have completely different outcomes because of small factors such as a history of mental disorder or anything that happened within the near past before the crime was committed would be factors in determining whether or not someone could claim mental insanity or intoxication.